Assalamualaikum. My name is Muhammad Azim bin Muhammad Hafiz. My metric number is 252685. I will present about the definition of Wasiyyah, wills, Wasiyyah, and the condition, pillars, and rules of Wasiyyah. Wasiyyah is defined as the connection, the good deed done during the deceased's life, and he will continuously receive the rewards for that upon death. Next, definition of wills. A will is defined as a person's iqrar that is made during his life to be acted out for the purpose of charity or for any other purpose permitted by Islamic law after his death with regard to his profit. Then, definition of Wasiyyah. Literally, Wasiyyah is defined as trusteeship. Technically, Wasiyyah means an act of requesting or enabling a person to do something after the giver of the trust is deceased or in his absence. There are a few types of Wasiyyah, which are absolute Wasiyyah, conditional Wasiyyah, generic Wasiyyah, and specific Wasiyyah. Alright, next, the conditions of Wasiyyah. The testator shall be in majority age, sound mind, and of free choice. The beneficiary shall not be the legal heir, who is also entitled under Fara'id, unless the other legal heirs have consented to him. The value of the Wasiyyah shall not exceed 1/3 of the property. The Wasiyyah can be made in oral or in writing. Next, the pillars of Wasiyyah. Testator, subject matter, sirah. Next, the rules of Wasiyyah. When a Wasiyyah is made to a person who, after he made settlement of his debt, is not an higher within the limit of 1/3 of the net property of the testator, the Wasiyyah must take place without the consent of the heirs, unless the heirs agree to the Wasiyyah after the testator is deceased. It is made to an higher in excess of 1/3 of the property must not be given effect. A Wasiyyah made by an indebted person must only take place after settlement of his debt, to the degree that it remains in his property. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nokurtul Afifah binti Hasbullah, metric number 254374. Okay, next I will continue to present the verses and hadiths on Wasiyyah. As we know, there are some surah in Al-Quran that mention about Wasiyyah. So, this is one of the verses which is from Surah Al-Baqarah verses 180 to 182. In these verses, we learn the significance of making will. Nobody knows when they will die and what people will do after them. If you wish that your rewards should keep increasing after you die, then you must donate a portion of your wealth to the project of continuous charity. If you do not wish your loved one to fight over your property, then leave them instruction. Besides, we also learn that Wasiyyah is not an additional responsibility, but for our own good. Therefore, it should not be treated light. While choosing a person for our Wasiyyah, we should make sure that they are trustworthy and God-fearing. They are not someone who are known to create mischief and will change the will as it may please them. If you are the person who has been entrusted with a bequest, then understand your important role, convey the Wasiyyah to others without adding or deleting any portion from it. Next, in verse 182, it has said that the will is not a final order. If later it is felt that injustice has been done, the alteration can be made with mutual agreement. Previously, we learned that the one who hears the will must not make any addition or deletion. But in this verse, a condition is being placed, which is if you sense biasness or injustice, and this will be done in mutual consultation with others and not on one's own opinion. So, this is a hadith reported by Ibnu Umar, which means it is not right for a Muslim who has property regarding which he must make a will that he should sleep for 2 nights, save that his will should be written down with him. Okay, next I will present about Will Act 1959 and Wasiyyah. A will and wasiyyah are governed by different set of laws in Malaysia. However, both serve a similar purpose, which is to manage a deceased person property. From this table, we can see that the testator's requirement for wasiyyah is must be a Muslim who is 18 years old and above, and for will act it should be non-Muslim who is 18 years old and above. Next, wasiyyah can be written, verbal or sign language, but for a verbal and sign language wasiyyah, it must be witnesses by 2 qualified witnesses under Sharia law. For will, it must be in writing. Next, for witness, both of wasiyyah and will need witness. However, for wasiyyah, the witness must be a person who are qualified in according to Sharia law. And for will, the witness must be by non-beneficiaries only. Then, method of distribution for wasiyyah, it used for fara'ids and wasiyyah beneficiaries, which is up to 1/3 of the testator's property. Last but not least, requirement of an educator. Both of will and wasiyyah has educator, but for wasiyyah, it is known as wasi. Wasi has the most important role in distributing the property of the testator to the rightful beneficiaries. So that's all from me. Thank you.
Assalamualaikum. My name is Shazwan Fikri bin Samsul Uzri. My matrix number 255496. Today I will explain the practice and the process of wasiyyah administration in Malaysia government. We have 3 wasiyyah administration here. The first one, Amanah Raya Berhad, Wasiyyah Shopee, and the last one, As-Salihin Trustee. Okay, we go through with Amanah Raya Berhad. Amanah Raya Berhad, also known as ARB, has an authority to administer the movable estate which the value is not more than 600,000. Either a person dies, testated or intestated, Amanah Raya Berhad will provide will services for both Muslim and non-Muslim. For Muslim, we will use fara'id distribution. For non-Muslim, we will use Distribution Act 1958 or Family Arrangement. Okay, I have separate into 2 categories. I have separate into 2 categories. The first one, without will or wasiyyah, or with a will or wasiyyah. For a person dies without a will, the beneficiaries need to apply for letter of administration from High Court to appoint administrator. After that, they need to see and compile deceased asset informations and documentations. The third one, beneficiaries need to carry out self-investigation on deceased asset and debts. After that, beneficiaries need to obtain LA from Amanah Raya Berhad, distribution order from small estate office from High Court. Another one, administrator need to realize deceased asset and settlement of debts, and need to prepare a complete estate account as per section 62 Probate and Administration Act 1959. Administrator will distribute the asset according to fara'id. Okay, we go to with a will or wasiyyah. Amanah Raya Berhad, as your appointed executor, will administer the estate according to your will. The second one, Amanah Raya Berhad have to apply letter of administration or grant of probate. Grant of probate is issued by High Court. Amanah Raya Berhad will distribute the estate according to your will. Okay, we go to next. Wasiyyah administration. Okay, for Wasiyyah Shopee, I have differentiate between tested and intestate. For tested, if a person dies with a will. For intestate, for a person die without a will. Okay, the first one, tested. Appointment of Wasi. Wasi is an executor or trustee, the person who will administer and distribute your possession, whether in local or foreign. Okay, collect informations. Okay, due to collect informations, Wasi need to seek all the informations needed in this making a will. So the testator are encouraged to list down the particular of each asset, including all local and foreign possession. Here we have to be honesty and transparency. Okay, after the death occurred, the testator asset or account will be frozen. Okay, the Wasi will apply for probate grant, as I mentioned before. A probate grant is a grant of permission issued by the High Court to the name of executor or Wasi of a will. The act empowering the executor to administrate the testator estate. And then settlement of debts. After done the settlement of debts, the Wasi will distribute of the estate accordance to will and faraid distribution. Normally, the estimate duration for a person dies with a will 6 months until 2 years. Okay, next, for intestate. A person dies without a will, death occurred, asset will be frozen, just like a testated. So, we legal heirs have to apply for a letter administration power from Mahkamah Syariah, and then we have to collect informations about the testator, the asset, the debt, and then we have to appoint 2 guarantors from the legal heirs, because we want to make honesty distribution. Okay, and then we will appointment of administrator. Okay, this one we appoint from Mahkamah Syariah, and then the administrator we ask us to settle off the deceased debt, and then the administrator will distribute of the estate account accordance to the Faraid Act of 1958. Estimate duration for a person dies without a will, mostly 2 years until 10 years. It's quite a long-term period. Okay, we will go to next. As-Salihin Trustee Berhad. This one is for private company. Okay, the purpose of the trust account is to ensure the beneficiary's benefits will be taken care continuously through a responsibility created between donor and trustee as they agreed in the trust deed. The immovable asset and movable asset can be deposited in a trust account. We have 3 forms of procedure as-Salihin Trustee Berhad. The first one, a testamentary we have three form of procedure in this Wasiyyah administration. The first one, a testamentary trust which is created after the lifetime. It can be stated in the Wasiyyah and takes effect on the death of the testator. First one, person dies with a Wasiyyah. Second one, a statutory trust which is automatically created by the law to protect the interests of the particular party, such as in the event of the intestacy. Intestacy, a person dies without a will or Wasiyyah. The last one, a living trust which is created during the lifetime. A living trust which is created during the lifetime of the settlor and takes effect immediately after completion of the process. A trust account for individuals can be assigned for the following purposes, namely charitable, family, education, and maintenance. Okay, that's all from my part. Thank you.
Hi, I'm Fatin. I will present about the importance of the grant of probates and the grant of letter of administration. So, let's go. The grant of probates and the grant of the letter of administration is same goes with Faraid certificate, but both of them is for non-Muslim and Faraid is for Muslim. What is a grant of probates, GP? It's type of grant representation of non-Muslim in Malaysia which applied for a person thus leaving a valid will through the executor and willingly as well as legally to administer estate. So what is a grant of letter of administration? It applied in case the deceased die in estate or partially in estate without will. So what the importance of GPA and JLA? First, give non-Muslim authority to the personal representative to deal with their estate or asset. The obtaining of the grant of probate is required as it formalizes and validates his actions in dealing with the deceased estate. For the grant of letter of administration, administrator derives his authority and power to deal with the deceased estate only when the court granted the letter of administration. Therefore, an administrator action is always subject to the court approval and permissions. Next, for distribution and entitlement to estate or asset, when the probate of letter of administration is granted, the executor or administrator may proceed with the duties of administration, starting from collection of deceased asset and payment of deceased debt and liability. After the payment of debt and liability, the executor or administrator shall distribute remaining of asset in accordance with the term of will or according to the Distribution Act 1958 for non-Muslim die in estate.
Assalamualaikum warahmatullahi wabarakatuh. I'm Nur Anisa binti Muhammad Ali, metric number 256097, going to present about issues of wasiyyah in Malaysia. So, the first issue would be contentious issues that inhibit will adoption are family misconceptions, family disputes, unhealthy relationship, superstitious, taboo, and sensitivity. So, superstitious and taboo showed highest mean scores among other issues. This indicates that Malaysians perceived will as outright superstitious and taboo as it is linked to premature death and thus lead to the hesitation of will adoption. So next, moving on to most of the Muslims in Malaysia are skeptical about making a wasiyyah. This is proven by the evidence by having a large number of Malaysian Muslims not having wasiyyah. Information from available resources indicates that awareness of wasiyyah practice is not very encouraging, especially among Malaysian Muslims. Further findings from a study conducted by Rosman and Abdul Razak 2008 shows that Malaysians' level of awareness and understanding on the importance of will, which is wasiyyah writing, are relatively low. So next would be lack of studies done on wasiyyah adoption in Malaysia where the law of Islamic will regulations is only endorsed by the state of Selangor, Melaka and Negeri Sembilan. However, there are still problems that occur with regards to the inconsistencies of wealth distribution upon death. This can be seen from a total of assets worth about 40 billion ringgit Malaysia left by Malaysians that are still not claimed by the heirs, as most of them passed away without leaving a wasiyyah. So next, besides that, under Wasiyyah Wajibah, the entitlement of the claimant shall not exceed 1/3 of the deceased estate. However, the enactment is silent on how the assets are to be distributed to the grandchildren of the deceased. Either it is to be distributed equally or to the ratio of 2:1 between the grandson and the granddaughter. As the enactment is silent on this matter, the presumption is that it will be divided equally, as uterine siblings would distribute their share of the estate under Fara'id. Despite all these issues, wasiyyah adoption by government agencies can decrease the frozen and unclaimed wealth. The importance of estate planning and wasiyyah knowledge should be disseminated by government agencies to create awareness about Islamic inheritance system among Muslim societies in Malaysia. That's all from me. Thank you.